you own a rental property and you're being sued, you're not alone because we're currently in a lawsuit ourselves. Small claims lawsuit. But there is a tenant that had moved out of a property that had their security deposit deducted and repairs were made to the residence, and the tenant is now disputing that. They are stating that the charges were done illegally, unlawfully, incorrectly, any other word that starts with an I. We are now having to go to small claims court. If you're in the same position and you don't know how small claims court works, let me give you the steps. First, you need to be served. You need to be served properly and fully. Usually, this means that you have to have proof of service. The court does not like having proof of service done by certified mail. They think it's one of the worst ways to go about serving someone, but it is possible to be served that way. More typically, you are served by a sheriff, an off-duty officer, or a company that does this as a job. Then you go to the actual court date. Yes, you do have to go to court. You cannot just waive this, assume that it goes away, assume no one shows up. Do not do that. Now, before you go to court, you can obviously try to settle this outside, which is what we recommend. If someone, a tenant, is suing because they had a deduction for $4,000 and they settle and say, you know what, I agree with half the charges, I don't agree with half. If we can make an agreement, we can just go our separate ways. That is an option that you can pursue. If, however, you are adamant that you billed correctly, you did everything correctly, that you are not going to give this tenant a dime, you have to go to court. Now, the named parties have to go. So if you are named personally, John Smith, you have to show up. You cannot have someone represent John Smith. You cannot have legal attorney representation in small claims court. But if you own a property in an LLC, call it Smith Enterprises, anyone can benefit and be the agent for Smith Enterprises. Your property manager, your siblings, your spouse, yourself, another person is able to go on behalf of a corporation. Not an attorney, though. So you go to court, and when you go to court, they try to arrange first a settlement. They'll have a discussion. If you want to settle or they want to settle, you'll go to a mediation, try to get that arranged. But if you do not, if you say, I do not have any plans to settle, I do not have any plans to mediate, they will then have the actual court date. That might be a future date. That might require you be in person. It might enable you to be on Zoom. It just depends on what your structure will be and if the filing is done. In court itself, the judge is very direct. The person suing you gets to go first, state their case, state their facts. They need to provide any of these facts to you as the landlord, as the person being sued. You then get to state your case. You state your facts. You state your deductions. You show proof, photos. This is what before and after looked like. This is the invoice of the work that was done. This is the completed work and what it was arranged by on a line item basis, provided by a contractor, even by yourself, but make sure you do it properly. Then the person suing you gets a rebuttal. You do not get to argue against each other. You are speaking to the judge, and at that point, the judge will make a decision. They will not tell you, typically, in the courthouse. I've been to small claims court more than 24 times. Only one time has a judge actually given me a statement in the court itself, and that was more so as an extension, and that was an interim judge. The actual permanent judges will go over the facts, the details. They will then make a decision and give you a notice in the mail a week or 2 weeks later. So all this to say, if you are getting sued, you're not alone, but we recommend getting out of a lawsuit. We recommend trying to settle. If it's obviously unreasonable, you're going to have to go to court. Now, one thing that does scare people is called the triple damages that a resident may be suing for. So smaller claims in California is $12,500. That means that I could say, you took $3,000 of my security deposit. I'm going to sue you for the original money, and I'm going to sue you on top of that for another $3,000 for my time, my image, my damages, my emotional damages. Maybe I sue you for the full $12,500, $3,000 of which is going to be for the actual deductions. And then the rest is, what I deem it to be fair, what I deem to be appropriate. Now, that is not legitimate. I want to preface that to say that when someone is suing, they need to be able to actually have a monetary value they're assigning to something and a proof that they're assigning it. I can't say my emotional health being damaged is worth $5,000. How is it worth $5,000? Did I take time off work and this is what I would have earned if I was at work? Did I have to pay for a cost of a therapist, of any sort of treatment? That is my actual damage. That is what I am able to really back up. Whatever your claim is that you are defending, you want to make sure that you have proof to back it up, whether you are being sued or you're suing a tenant. If that's the instance because they had damages to your home, you need to have proof that you're backing it up. Now, our recommendation again is to let bygones be bygones. It is to try and arrange a settlement, an agreement, a middle ground, because what is your time worth? To go to court, which, by the way, never goes fast. It's at least 3 hours. If you're the last person called, it could take 6 hours. Then you're having to arrange all the documents. You have to get ready for this. What is the stress that you're putting on yourself or the anger that you're putting on yourself about having to go through this scenario, the preparation for it? What is that worth to you? Versus what is peace of mind worth? Might be worth it.